Good morning, afternoon, or evening. Welcome to All Things Social Security. I am Stephanie Joy, the attorney at Joy Disability. Welcome to the channel, and I hope you enjoy the video. Have a great day. Bye-bye. Good morning, afternoon, or evening. Stephanie Joy with All Things Social Security and the law practice of Joy Disability. I wanted to run over with you guys about a case that came out recently in the 11th Circuit, and it's got some reminders that I think it's really important that people understand. It's some hard truths, of course, in the Social Security disability law area. And so I'm just going to go through my notes about what I think you need to know about this one. I said it was 11th Circuit, right? Because this surprises a lot of people. I mean, a person can have real medical problems, they can have real pain, real fatigue, and still lose their Social Security case, not once, but twice or more. It happens all the time. It's not just a theory. So in this case, this particular federal court decision, it went up to a circuit. The case involved a fellow who alleged disability based on several impairments, physical. There was spinal issues, there was fibromyalgia, carpal tunnel, low testosterone, which caused the fatigue. And he also had argued that psychological factors affect all of these things, make his pain worse, and that, of course, he had significant side effects from his medications. Now, always remember that the whole idea is he had to prove that he couldn't do any of the occupations that exist in substantial numbers in the the regional or national economy. And there's over 12,000 of them. So let's get to it. I mean, when you look at it, it looked like a serious case. There's multiple diagnoses. I mean, it's not like he wasn't found to have diagnoses and severe impairments. There's multiple symptoms. There's multiple ways these conditions could interfere with work, but he still lost. The ALJ, administrative law judge, found that he had several severe impairments, indeed, like the ones I mentioned, but still concluded that he could perform a limited range of light work. So if we have the full range of light work, and I forget how many of those 12,000 jobs are considered to be in the entire light range sector. Remember, there's sedentary, light, medium, heavy. So when they said limited, that means the judge found he couldn't even do all of the ones in the light, only a portion of them. But remember, the verbiage under the law is if there is occupations, a person can do if the occupations exist in substantial numbers in the economy. So the job has to exist in substantial numbers. They don't really define what substantial numbers is, and everyone's all over the map on that. A few thousand, we argue, is not substantial numbers, a few thousand, but there's not much rhetoric about, there's no flat number that the SSA provides to know at what point they would draw a line. And I think judges can vary. I think they do that on purpose so that there's some discretion. Okay. So the judge found limited range of light work. Claimant obviously appealed. Appeals counsel obviously declined to review. And then he took it to federal district court. We talked about this before. There are federal district court attorneys that focus exclusively on that. Some really good ones out there. It's not bad to know of one before you even go to hearing, but if you come out of a hearing, get a bad decision, you're going to want to even though you're going to go to the appeals council and you can do that by yourself quite easily. I mean, super easily. I have a video on that, I believe. But now's the time to get your feelers out there for an FDC attorney, federal district court attorney that does Social Security work. You can't actually give him your case yet. He's not going to spend the time looking at it since he's not getting paid until you are denied by appeals counsel. And then that's when you're going to get him and give him your ALJ denial. If you happen to have an appeals counsel brief, which you might not, if you're pro se, you don't have to have one. They're kind of obligated to review the whole thing with or without one. But that's the time to start knowing that because they are not easy to come by. So you want to maybe have a handful of names that take cases in your territory. And that's something you could actually call their office and say, do you guys handle FTC cases in so-and-so town in Pennsylvania? And they're going to figure out what, district that is. and they'll know if they do it or not, or if they have someone that does it with them. Because no, you can't just go and, we attorneys are limited to where we can go unless we do special things. And some of the ones that do federal district court, I wouldn't say most though, do have a whole big, almost like they have people in every state. Because really the one guy over here can do all the writing of the brief. The other guy just has to be the name on the paper. All right. So that's just a little bit. Federal district court. That's where he took it. Federal district court obviously declined him, and it went to the 11th Circuit, which is the one that listens to all the federal district courts underneath its umbrella. The 11th Circuit affirmed the denial also. The result, I'm sure, and this happens all the time, particularly with certain conditions like these, it's really frustrating for claimants. And frankly, it can be hard for people to understand, and I totally get it. A lot of people will hear facts like, do you hear the dogs? You hear those dogs? Got my bracelet all caught. A lot of people will hear the facts and think, well, how can someone with all these problems be denied, right? The guy's got fibromyalgia, he's got spinal issues, he's got severe fatigue issues, probably depression. And that's why I want to talk about this case, because it's really hard to understand the strength of your own case when you're in the middle of it. Because you know the reality that you can't work, that you cannot get through an 8-hour day. So doesn't mean you're useless. You can maybe do 4, but you cannot do, as they define it, an 8-hour day, 5 days a week on a sustained basis. So let's get to the whys and how that can happen. And so it might help you be able to prevent that particularly if you have these kind of cases. And I'm going to say it applies to everybody, but it's particularly applicable to people under 50. So you got to remember, Social Security does not simply ask whether you are sick. It does not simply ask whether you have pain. It does not simply ask whether your diagnoses are real. It'll know whether your diagnoses are real from the medical records. Rather, what the Social Security is going to ask is ask itself as the adjudicator, whether the evidence you provided and it's been able to help you get proves that your medical conditions limit you so much that you can't perform substantial work activity under the law. So it gets very almost like tunnel visioned on, well, that's severe stuff, but does that eliminate all the questions under the law that this person is tasked with proving he can't do? Because disability benefits do not go to people who have an option in terms of physical and mental abilities to do a job over there. Whether or not, because if they could, back in the day before Social Security disability was even a twinkle in the eye as a program, what did people do when they had to support their families and they had impairments? They found something they could do. They did. People got up and went. And then we made it a little bit easier so they didn't have to do that. So anyway, the question of whether someone's sick and whether the symptoms and the consequences of the impairments are severe is not the only question. It has to come down to the jobs. You have to get to severity, and then it comes down to the jobs. So you have to prove they're severe, or at least one, and then the question is about the jobs. So when a case goes up on appeal and the reviewing court, such as the 11th Circuit in this case, usually it's not taking a fresh look and deciding for itself whether you should win, you the claimant. The court's usually taking a much narrower question, and that is, did the ALJ have enough evidence in the record to support the decision? And that's pretty much what the AC, Appeals Council, does also. And the standard that this is called is substantial evidence. Did his decision incorporate the substantial evidence? It doesn't have to be every single piece. And it's what makes those appeals, I think, really hard, because substantial evidence, let's say that means, and this is like a made up way of looking at it. Substantial, a lot. Okay, 60%. Again, this is just for visualization purposes. Well, okay, he considered 60%, and he thinks that turns into there's 5 jobs you could do. 5 occupations that exist in substantial numbers. Well, then you lost, even though there's 12,994 jobs you couldn't do. You follow what I'm saying? Like, it is such a high bar. So the phrase substantial evidence, it sounds stronger than it really is. And that's why they're able to find that you didn't meet it. A lot of people hear it and assume that it means that the judge's decision has to be supported by overwhelming proof. That is not what it means. It's far weaker than that. His opinion just has to be supported by the substantial evidence. It doesn't mean that the reviewing appellate bodies after that, the appeals council or the federal district court, have to reverse or remand if they personally in their own little heart, after reviewing the ALJ decision and stuff, decide that you wouldn't be able to work at any job that exists. That's not the standard. Their standard is not to substitute their judgment, just to find out, did the judge base it on substantial evidence? If he did, even though I wouldn't have done the same thing, we have to uphold it. And that's because the judge's decisions have to have a level of finality. Okay. So yeah, it doesn't have to be overwhelming proof, guys. It's not like criminal law where it's proof beyond a reasonable doubt. One might say it's not even clear and convincing, which is another standard that's above preponderance of the evidence. Back when I used to do state law. That's just not what it means. So in more practical terms, I'd say the substantial evidence is a very deferential standard to the ALJ. If there's enough evidence in the record that a reasonable person could agree with the ALJ, a reasonable person could agree with the ALJ, the court will often affirm it, even if the record could also support different outcomes. In other words, even if another judge might have ruled for the claimant, and as you know, judges have different award rates, and we have to assume that's not because they have vastly different cases, generally speaking, but that does not necessarily mean that the denial gets reversed. So, yeah, just because you and I would find differently, even if the appellate court individual member on the panel would have decided differently, and another ALJ would have decided differently, that is not the standard, because the ALJ that decided it gets a bit of deference. Anyway, that's why the appeals can really feel unfair, and so do the ALJ denials, of course, feel really unfair from your point of view or claimant's point of view. A claimant might think, but I had evidence, I had diagnoses, I had complaints, I had treatment. I did everything to get proof of what I am saying. And that can all be true, but if the ALJ gave a reasoned explanation and pointed to parts of the medical record supporting a denial, the court will often uphold that decision. And that is exactly what happened in the 11th Circuit case we're talking about. One of the main arguments on appeal involved the claimant's pain complaints. And this is huge because almost everyone that files a SSD or SSI claim, I'd say almost everyone has pain. It just seems to be one of those things that stem from medical impairments. Not always, but often. Anyway, the claimant had argued that the ALJ didn't properly evaluate his subjective complaints of pain, including the role of psychological contributors and medication side effects. So those arguments are good because the ALJ does have to consider his subjective complaints of pain, psychological contributors, and they even ask for some of these things in some of the reports and all that you produce as you're going through your case that they demand of you. And as you know, I'm sure you all remember, the medication side effects can be really important. And they can tip it over, but they don't necessarily tip it over like in this case. So, and it does often come up where we use those. And the more those medication side effects are found in the medical record, that the claimant has been complaining about them, and it's been a real problem. Maybe they've even tried adjusting medications over and over again because of the side effects. That's helpful too, just as a little aside. But going back to the case and claimants in general, claimants often suffer from symptoms that don't always show up neatly on an imaging study or a lab result, and that pain is one of them. I would say fatigue is another one, and that's very real. And medication side effects generally don't show up on an imaging or an MRI or anything like that. The psychological factors also don't show up, but they absolutely can interact with physical pain and make a person's functioning worse.